evening. It's wonderful to be back with all of you at Candlelight. Thank you so much for having me back again for a second presentation on constitutional law, which of course is one of my favorite subjects to talk about, and especially with all of the current events going on in our society, there's a lot more emphasis on being more constitutionally literate, which is always a good thing. We as patriots and citizens of this great nation need to understand what our law says, what our rights are, and what our Constitution means. And that's our topic tonight, is originalism and the Constitution, and then we will also be talking about the Bill of Rights. So we're going to start with this quote from Thomas Jefferson. "I consider the foundation of the Constitution as laid on this ground, that all powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. To take a single step beyond the boundaries thus specially drawn around the powers of Congress is to take possession of a boundless field of power no longer susceptible of any definition." So what Jefferson is talking about, of course, is the doctrine of originalism, what the Constitution says and what it means. So we're going to be understanding originalism tonight. What is the doctrine of originalism? It's the theory of interpretation of the Constitution, and there are two main theories, really. One is the doctrine of originalism, meaning that it was fixed at the time that it was written. It is not a fluid document or a fluid concept. It's not something that evolves and changes over time. It has a fixed meaning at the time it was written, and that fixed meaning is still applicable for us today. So it is a written document that is not unique. Certainly our Constitution is unique in some aspects because it is the United States Constitution. It says something completely different than any other written document. But what I mean by it's not unique is that it is no different than any other written document or written constitution. Just like my book that I wrote is certainly unique in terms of the ideas that it presents and what I had to say, that's why I can copyright it, but it's not different in the sense that it is a written book. We have millions of those. So it's not a unique document in that sense. It's written in the English language. And that's helpful for us because we don't have to interpret it. There are no other problems in terms of our understanding of it. It's the original document that is available. We actually have it in our National Archives. And so in law, we call this the best evidence rule, meaning that we actually have the original. We're not looking at documents that have been copied and copied and copied and have any sort of argument of interpretation for the original meaning based on copies or interpretations. So we do have an identifiable original exclusive meaning. That really comprises the doctrine of originalism. So there are 5 principles to understanding originalism that really can apply to any text that we're talking about, and they certainly apply to the U.S. Constitution. The first one is authorial meaning. The author chooses the words and phrases, just like how I'm choosing my words and phrases to convey a specific meaning for you, the audience. I establish the meaning because I'm the author, just like the founders established their meaning in the Constitution because they specifically chose the words and phrases that they set down to specifically convey an intended meaning. The author's implied intent is to convey that specific meaning. So miscommunication occurs when the reader doesn't understand the author's intent. It's not necessarily the fault of the author who's trying to convey a specific meaning if the reader doesn't understand that. That is miscommunication. But meaning has to be inherently vested with the author and not left up to the reader. Otherwise, we don't have one meaning. So, for example, if I were to tell a loved one, I love you, my meaning is what is binding. So they could interpret that a lot of different ways, but what I mean is by the words and phrases that I'm choosing to say. So if I say I love you, then, and the reader or the listener interprets I hate you, then that may be miscommunication on my part, but it's not my intent. And so the reader or the listener needs to understand the author's meaning. Principle 2 is exclusive and original meaning. One exclusive original meaning. And that will, by definition, logically and necessarily exclude all other meanings. So the meaning doesn't change just depending on the reader. It's not relative. You may all go away from this seminar and discuss what I've said. You may read my book and disagree or agree with the concepts that are in it. But that doesn't mean that my intent as the author or my exclusive original meaning changes just because you would agree or disagree with something that I as the author am saying. So meaning doesn't change just depending on the perception or the understanding of the reader. It has to be one exclusive original meaning. Otherwise, we don't have communication. So intended meaning then is not negated in any sense by the failure of the reader to comprehend. That's a really important point. Just because you may disagree with something that an author says, or you may not fully understand it, or you may think that the author didn't choose their words very wisely, that doesn't in any way logically negate the intended and exclusive original meaning of what the author intended to convey. So then principle 3 is the objective, concrete, and binding meaning. We've touched on binding just a little bit. And what I mean by that is the plain meaning of the text. So unless the context or the author specifically states otherwise. So we've all read Aesop's fables, we've read poetry, we've read other things that are intended to be allegorical or to be a parable. We see the parables in the Bible, for example, that we know that Jesus didn't specifically mean there was actually a Samaritan man. It was a parable. But the important point of this is that he, the author, specifically told his audience, I'm telling you a parable. They understood the context, and he, as the author, intended to convey that particular context. So the plain meaning of the text is objective and it's concrete unless the author pre-establishes to the audience, this is an allegory, this is a fable, this is a poem. There's no way to have symbolism, fluidity, or non-literal meaning unless the author specifically intends that. We can see a lot of the problems with interpretation of Scripture, for example, are because a lot of readers of the Scriptures ascribe symbolism or parables or allegories in ways that were never intended by the author. And by the context, that's simply not the original objective and concrete meaning. So binding meaning is that the reader approaches the document or the written word as assenting to the author's meaning. So the reader is not free to assign a different meaning at will. We can see this clearly, the example that President Obama has recently given us with his edict, which was trying to be an interpretation of the Civil Rights Act and the non-discrimination laws, by going back and saying, okay, even though that was established in 1964, we are going to go in and assign that term sex to mean gender identity. And we're going to twist that, and we're going to ascribe a different meaning. He's not giving that law the objective, concrete, and binding meaning that it was established by the authors when they created that law. So the reader or the executive office is not free to assign a different meaning at random or at will. And we see the Supreme Court doing that with the Constitution quite often, because they will go back in and take one particular phrase or sentence and create an entirely different meaning rather than giving it the objective binding meaning that was intended by the founders at the time that the document was ratified. So it has to have a logical meaning. anything that we read has to have a logical meaning. Certainly we can see sometimes poetry doesn't necessarily, but again, the author intended it that way. They intended it to be either poetry, allegory, words and phrases that the reader is then free to say, well, what does this mean for me, and talk about it that way. But importantly, the author still told the reader, that is my intention for this document. Unless the author has specifically said, you are free to read this as a parable or as a poem, it is objective and concrete, and especially with legal documents. The context of legal documents and the way that they are set up specifically exclude any sort of allegory, parable, fluid interpretations, or otherwise imputing to those words any other meaning or definition other than the logical legal meaning. The founders, most of whom were lawyers, they understood the specific words and phrases of legal terms of art, and they specifically set down both the Declaration and the Constitution to have very specific legal meanings that were objective and concrete. Because it is a legal document, we can understand that and know that for certainty. So that brings us to principle 4, which is the contextual meaning. And so contextual meaning is that communication always has a context. Here, when you all came to see this presentation, you understood that the context would be that I'm a constitutional attorney, so I will be talking to you about originalism. You have a context for my communication. So you already understand that there is an author, there's a time, and there's a place. We are in the age and year that we're in, and that provides the place and the context just like legal documents do. Contracts, for example. If we are looking at a legal document and there was a contract that was ratified by 2 corporations in America, we understand just by the context and by the specific terms and phrases within it, their choice of law section usually, that this will be either arbitrated or litigated according to the laws of this particular state or jurisdiction. That is understood then by the reader to have a specific context. If there is any dispute over performance of the contract or any other element within that specific language, then the reader understands that is the choice of law. That is the context. The Constitution, likewise, has a context, and we're going to look at the pyramid, or what I like to call the founding documents hierarchy, in just a moment after Principle 5. So we also have to look at the macro level, the scope and the purpose. And so the scope of the document is, what is it doing? What is it attempting to convey? For example, a contract. It will say at the very top and the heading as a legal document, these are the 2 parties. This is the purpose that we are creating this contract. That is the scope. And that means that the contract does not pertain to anything other than what it is intended to. And what we as lawyers say is the 4 corners of the document. So the Constitution, while not a contract, certainly has a scope, and it also has a purpose. It was written specifically and intended to be the supreme law of the United States, and we see that specifically in the Articles. So we see that is its scope and that's its purpose. The micro level is a word within a sentence within a paragraph, and so on. Even the sentences that I've put up as my PowerPoint presentation, you see that I've chosen each word to convey a whole meaning within the context of the presentation, and then within the sentence that's within a bullet point, and then the word in its placement in that sentence structure. That's linguistics. We understand that the author chooses those specific words and phrases in order to convey a specific meaning. My first bullet point, the words that I chose, communication always has a context. You hear those words, you hear that phrase, you know what I mean. Based on our setting here, our context, based on the author, based on what I told you at the outset was my intent to talk to you about tonight. You know that we're talking about originalism. And then you also know within the placement of the presentation that this is a subcategory or bullet point under Principle 4. It's not that hard. Those types of interpretations and those original intent pieces we use every day when we're reading and when we write in order to communicate. If we didn't have these threshold principles, miscommunication would happen all the time. We would never be able to use a written instrument in order to convey an author's meaning. And it would never be able to be properly interpreted if we simply said, well, this is my intent, but I'm giving it to the readers, and I have no idea what they're going to take from it. I have no idea what meaning they're going to ascribe to it. That would be absurd. We would no longer find reading or written instruments necessary or even productive. So we have to look at the macro level, which gives us our scope, purpose, and context. And then we also have to look at the micro level. We have to understand, why are the words there? What is the purpose of the overall sentence? And contextual clues pinpoint a precise meaning. And so that, again, would be what each word is situated within the sentence to mean. So context is incredibly important. And so when we are looking at the Constitution as a written document, the context is incredibly important to understand what is our Constitution. So much of the misconception about the Constitution is that it is a magical document that is fluid, that has no concrete meaning other than what our Supreme Court justices give it, and it doesn't fit within any particular time or place because we have been taught the legal fiction that it evolves over time, that it means whatever we as society want it to mean today. If that were true, why even have a constitution? Why would we even uphold this as the supreme law of the land? What would that really mean? Well, nothing. It would simply mean that the justices who are sitting on the Supreme Court, or executive actions such as Obama's that just recently happened, they would simply have to appeal to that basically just for sake of showing that they cared about this antiquated historical document for no real purpose. It would just be, you know, we're gonna tag the Constitution because we feel more American. It doesn't really have any meaning if we can go back into the Constitution, take out words and phrases, and ascribe to them whatever meaning we want. If context isn't important, if communication and precise meaning is not important, then the document itself becomes meaningless. When I go into court, and if I'm litigating a contract dispute, for example, or a written lease, or any other agreement between two parties, I always say, Judge, this is what the document says. When I have the original document, the best evidence, the court will look at that and they will take the objective, concrete, and binding meaning. No judge in a contract dispute has ever said, well, counsel, this document is so magical that I just need to, it's fluid terms. You know, you entered into it 5 years ago, and the meaning of performance and saying that you are going to pay, that your client is going to pay the plaintiff $500, well, that means something totally different today. No, they're not that stupid. They understand that written, meaningful language is precise and it conveys communication. So the contextual clues pinpoint precise meaning, and we have an entire body of case law that tells us what terms and phrases mean. We have an entire linguistics of the English language. The founders had a huge grasp on not only the English language, but also the legal language to specifically set down what they intended for the supreme law of the land to mean. So finally, principle 5, meaning through consideration of the whole. It's really important that all 5 of these principles are taken together. Because if you take only one and you say, okay, we're going to go with the author's intent, Where does that get us? That gets us to a debate on who the founders were. Were they Enlightenment Christians? Were they conservatives? Were they libertarian? What does that mean for us today? Well, we're forgetting the best evidence rule. We're forgetting that it is a written document. We're forgetting the binding, concrete, and objective meaning. We're forgetting the scope and the purpose. So if you take only one principle and you try to apply that, you may get to a partial truth, but it will only be a partial truth. So we have to take and apply these together for the correct meaning. Meaning is derived through consideration of the entire document. No proof texting. Proof texting is a term that means taking one word or phrase, lifting that out of the document, and then building an entire doctrine around that, such as equality, or equal rights, or the due process clause, the general welfare clause. All of those things are lifting terms that are in the Constitution. The general welfare clause certainly is in the Constitution. But rather than going back and reading what it actually says and taking the meaning in context, the word within the phrase within the paragraph, the entire document as a whole, and then in context, we are then lifting it and actually narrowing it and saying we're now going to build an entire doctrine just around that phrase. What does general welfare mean to us today? We are ascribing a new meaning and building an entire doctrine around that. We can again see the parallel with how some teachers of Scripture take out of context some of the words and phrases in the Bible. And some of them, again, they're very well-meaning, but they don't take the phrase and the context of the entire Scripture, and so the application and the ascribed meaning may be a partial truth. Or it may be something that is true of God's character or true as a general principle, but that particular scripture is not what that verse is intending to convey or the particular meaning. Just as it's important to read every written document, and certainly the Word of God, with an originalist view, understanding God as the author, what did he intend to convey? Leave him with the authorial intent. Respect that. That is also what we have to do with the Constitution. So we can't have any doctrines around one word or phrase in the Constitution. Otherwise, we get to this fluid document that we really have no idea what it says or what it truly means, because all we've been taught by the Supreme Court is that we're going to apply this legal doctrine. Notice how they often refer to the legal doctrine rather than the whole sentence structure of the Constitution itself. They refer to the doctrines that they have lifted out of the terms and phrases in the Constitution and have built entirely new doctrines that suit their own progressive agenda and purpose. One of the cases that completely started this was Connecticut v. Griswold in 1965, which was where the penumbra doctrine was created. And if you read my book, there's an entire chapter on there about how did we get from an originalist, concrete constitution to this mess that we're in today. And I take you through a series of court cases that broke down the barriers of the constitutional law's original concrete and binding meaning and started to ascribe new meaning to each of those phrases. And Griswold v. Connecticut was one of them, where this so-called penumbra doctrine was born. What that was that the Supreme Court wanted to make contraception legal. It does not have the jurisdiction to do that within the specifically granted and limited powers given in the Constitution to the Supreme Court, so they had to create a fiction. They had to create a legal fiction and go back and say, well, where in the Constitution can we possibly get this? They couldn't find it anywhere, even in a text, that they could possibly create a doctrine, even out of one word. So they decided that they would literally read between the lines of the Constitution and take the space in between the lines of the black letter words. And they would say, well, these rights emanate from this penumbra that's in the shadowy parts of the Constitution between the lines. That doctrine is taught in law schools In every ABA accredited law school in America today, the penumbra doctrine is considered fact in the Constitution because the Supreme Court said it. That's absolutely false and absolutely ridiculous. And that's why originalism is so important and why it is so important to take these 5 principles and apply them to the Constitution as a whole. We as constitutional conservatives and as citizens of our country have to not only read the Constitution for ourselves, but understand what it actually means. So we are going to go through that and talk about why the meaning is vitally important. This is what I promised you, the founding documents hierarchy. This is the Constitution in context. Anyone who was here before who heard my presentation on the U.S. Constitution and its origins is familiar already with this pyramid. What this means is that the Constitution is not just a document that sits out there in a vacuum. We are not supposed to just read it as some sort of document that is shifting around, and when the Supreme Court wants to grab at it, they can try. It is very firmly fixed in history and as a legal document in context. It is rooted in the basis of divine law. What I mean by divine law is what the founders would have called natural law. Natural law meaning law that comes from God, that is rooted in both general and specific revelation that we know just by the reality of the universe to which God has presented us to. We know that there is light and dark. We know that there is good and evil. We know that there is morality because we exist in this universe. And God prescribed specific laws that include laws of nature, how the progressives have gone back in and said, well, that only applies to scientific principles. That only applies to things like gravity, like things that we can empirically observe. So why I prefer the term divine law is that we are expressly recognizing what the founders recognized when they said natural law. Again, they're taking that phrase and trying to make it mean something else. So we can talk about it in terms of specifically recognizing a creator. The founders did that. They specifically recognized in the Declaration of Independence, we hold these truths to be self-evident that all men are created equal and endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. And so the government's only proper role is to preserve and protect those unalienable rights that come specifically from our foundation. That was the founders' worldview statement. That was their mandate of saying government's only job is to preserve and protect our rights, not to grant us our rights or to specifically define them for us. That's not the role of government. God does that. Our rights come from our Creator. And they specifically put that in the legal document of the Declaration of Independence. So then, once they had established the only proper role of government, they said, okay, what type of law does this? How can we give specific, limited powers to our federal government and then reserve all other powers to the state governments in order to preserve and protect the rights of every single citizen in this country? So the Federalist Papers and also the Anti-Federalist Papers were their debates, like lawyers do, back and forth, to say, what do we think about this? What is the best law that we have? Ultimately, in 1787, the Constitutional Convention created the Constitution. It is not a contract between we, the people, and the government. What it is recognizing, per the mandate of the Declaration of Independence, that our rights come from God. We, the people, then, as a collective, give certain limited powers to the federal government by virtue of that authority and say, this is what you as a federal government are allowed to do. That is all that the Constitution is specific, limited powers of the federal government. It is not where our rights come from. It is not that if the freedom of speech or freedom of religion were not textually written into the First Amendment, we wouldn't have it. No, it's simply the limited powers given to the federal government to regulate our country, because our founders recognized that the proper role of civil government is to preserve and protect our rights. They understood that's the civil government, just like it's the family government of the parents to act as the authority and to set certain rules so that we have a well-ordered family. Like the church government, we see those principles outlined in Scripture of what a church should look like in its church governance. So all that the Constitution is are the specific limited powers. It's not anything else. So we have to understand that the Constitution sits on top of this founding document's hierarchy, and it is rooted specifically recognizing that God is the ultimate origin and arbiter of law. Our Constitution expressly recognizes that. So when people tell you, well, the word God doesn't appear in the U.S. Constitution, that's true. But it does appear in the Declaration of Independence. And you cannot have the U.S. Constitution without the Declaration of Independence. They're both legal documents. So when it starts out as we the people, that is a continuation of the Declaration of Independence, of the worldview statement, now saying, okay, then we the people who are created by God, who recognize truth exists, we now are going to create the supreme law that is going to govern us by giving certain very specific, limited powers to government. So let's look at the Thomas Jefferson quote again, now in context of everything that we've been talking about. The foundation of the Constitution is that all powers not delegated to the United States or the federal government by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. That is quoting the 10th Amendment. To take a single step beyond the boundaries thus specifically drawn. He's talking about this not being fluid. This is not just the whim of the Supreme Court. Very fixed boundaries, specially drawn, intent, purpose, concrete, binding meaning around the powers of Congress is to take possession of a boundless field of power no longer susceptible of any definition. That's exactly where we're at today. Our Constitution now has hardly any definition according to the Supreme Court, but we know otherwise, and we need to be teaching this, and we need to be reading our Constitution, understanding that we as citizens don't need to be lawyers, we don't need to be justices on the Supreme Court to understand our Constitution. It's very plain. So let's look at it. The U.S. Constitution is a legal document that grants specific limited powers to the federal government. Article 1 simply talks about the legislative branch. We've all heard the three branches of government. Article 1, Section 1 says all legislative power is given and vested in Congress, period. Then it goes and states what things is the federal Congress allowed to legislate on. They're very specific things. It is not allowed to legislate outside of those specially given powers. Article 2 is the executive branch. That sets up where the president has the power to be our commander-in-chief of the military. He has the power to nominate a Supreme Court justice with advice and consent of the Senate. That's been in the news a lot lately. And that comes directly from Article 2. It's very simple. He has the power to nominate. That's it. It does not say he has the power to regulate the facilities use of every single publicly funded institution in America. That's not in there. We can see that, and that is not at all something that the executive branch can do. Article 3 is the judicial branch, and that all judicial authority is vested in one Supreme Court. It says it right there. The executive branch does not have the power to interpret law or to be a substitute for the judiciary. Article 4 is the states, talking about how new states are added to the union. There's a specific process for that we have state sovereignty. Article 5 is the amendment process. We're going to talk about this a little bit more in a minute, but what the amendment process is not that we can go back and change the role and scope of the Constitution. It's not that we can go back in and say, now we as the government are deciding what unalienable rights God has given to you. No, God has given us our rights. We already have those. Any time, place, society in history, any human being, because we are made in the image of God, have these rights. So the amendment process is simply if we need to redistribute some of these powers or rein in the federal government and say, you know what, you are not very responsible, federal government, so we, as the people who consent to your authority, are going to take away your power, President, to nominate a Supreme Court justice. We would rather the states be responsible for that because you have proven that you are not capable of not abusing that power. We can go back in Article 5 and we can amend our Constitution in order to redistribute the powers to the federal government or take some away and give them to the states. That is all that Article 5 is. Article 6 is the legal status of the Constitution. This is where the founders specifically set up the Constitution as being the supreme law of the land. That's where we get the supremacy clause from. And then finally, Article 7 is just the ratification process, which is the founders as lawyers understood that in order to be a complete document, they needed a ratification clause. So by virtue of how this was set down, everything it's contained, the four corners of the document, and how we can apply these meanings and these principles of originalism to this. We understand it is a legal document. We understand its role, its purpose, and its scope, and we also understand what it is not, which is that it is not the document that gives you the right to exercise religion and worship God. It is not the document that gives you the right to free speech or freedom of the press. It is not the document that gives you the right to keep and bear arms. Those rights are already yours. The Constitution only gives the federal government power to legislate according to its specific mandate, and then the Bill of Rights is not the document or the part of this document that gives you those rights. It's actually completely the opposite. There were rights that were so important to the founders to specifically enumerate. When the media or any lawyers that you've heard talks about enumerated rights, all they mean by that are rights that the founders in context believed were so important among all other rights that we already have to specifically limit the federal government's power to regulate because they are so important. So the Bill of Rights is the first 10 amendments to the U.S. Constitution. Again, it does not grant rights to the people. The Bill of Rights limits the federal government's power to legislate or act relative to a specific right. So I've talked about Alexander Hamilton before, and in Federalist 84, which I highly encourage you to read, he specifically was against including a Bill of Rights because although people like Madison were very concerned about these specific rights, we need to specially limit the federal government's power on these very, very important rights. His concern was that if we call it a Bill of Rights, for such as they are contended in their arguments in the Constitutional Convention, if we add a Bill of Rights, it's going to look like the government is the one that grants us those rights. And people, say 225 years later, are going to look at that and say, well, the government then can regulate them even further because they are specifically enumerated in the Constitution. That's exactly what happened, and that is completely the opposite of what the Bill of Rights was intended to do. And let's look at this. Let's look at the actual text. So we'll go through a couple of amendments here. The First Amendment, Congress shall make no law. That's a specific prohibition. That does not say Congress, by virtue of the Constitution, is giving you the right to religion and the free exercise thereof, the right to freedom of the press. No, this is saying Congress, the federal government as the actor in this situation, will make no law. They are specifically saying that within Article 1, Section 1, Article 1, Section 8, and the legislative authority, that will not and shall not be construed in any way possible as respecting an establishment of religion, prohibiting the free exercise, or abridging the freedom of speech, of the press, the right of the people to peaceably assemble and to petition the government for a redress of grievances. All of those things we already have. So you can see that the actual text, if you don't just take free exercise and you lift that term out of the First Amendment, and we listen to the Supreme Court talking about the free exercise clause, that's what they like to talk about it, because they have built an entire doctrine around the free exercise clause that is absolutely contradictory to what the First Amendment actually says. All it says is that Congress can't make any laws about it. That is all that it says, and that it will not respect an establishment of religion or prohibit or abridge. The Second Amendment, which I know up here in Idaho is very near and dear to our hearts. It is in Colorado as well. And it should be everywhere in the United States. All it says, look at the last phrase, shall not be infringed. The founders understood that the right to bear arms, our unalienable right to self-defense, to having the ability to protect our life, liberty, and property, that will not be infringed by any laws of Congress. So what does it say? A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That is so obvious. There is an entire Supreme Court case that talked just about one of the comma placements of this case and how they were going to build an entire doctrine just based on the comma placement in this amendment. None of us here need to be lawyers to see that this is so obvious in context, and especially in context of what we understand the Constitution's role, scope, and purpose to be. So this is really easy stuff. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated. So what the Supreme Court has done is gone in and taken the unreasonable word out of this and has created whether or not this is reasonable to have a search and seizure. And there is so much case law, particularly in criminal law, in the criminal law context, which is what I litigate primarily, and they've taken that one word and built an entire doctrine around it. And they've added on to the beginning of this phrase, the right of the people to be secure. Well, the right pre-exists this amendment. We understand that in context. But what they've done is go back in and say, we're granting you the right to be secure in your persons, houses, papers, and effects against unreasonable searches and seizures. And we're going to define what unreasonable means and what it doesn't mean. And that evolves over time as police and law enforcement technology goes further and further, and as we see what the public policy issues are and how we need to balance the interests of the individual against the drug war, et cetera, et cetera, et cetera. And they go and they create all of this legal fiction and doctrine around one word that in context we can see very clearly shall not be violated. It's that simple. And no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. We can understand that in context, the founders were very concerned that, like they had experienced in England and in the British courts, that a warrant or what was called a bill of attainder would issue, and the individual who's being charged with a crime didn't even know what it was until they got to court. They could be detained, and the law enforcement could just come in at will and say, we're going to search your house because we have this bill of attainder. They specifically said, no, that is against your right to be secure in your person, and that right comes from God. That comes from our declaration statement that is rooted in the law of God and his imposition of law on reality. We specifically have that right so near and dear to our hearts that we want to make sure that we set this down in the Constitution, that cannot be abridged except upon probable cause and specifically articulated. That's all that means. The Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime, nor shall, and you can see I've bolded this, no person shall, nor shall, nor be. That is an indication that they are even further the authors are even further limiting the federal government in their ability to legislate or in any way have judiciary authority that is in contradiction to our rights. So it is the right of a person to not be subject to the same crime twice. That's fundamental fairness. Or be compelled in a criminal case to testify against themselves, nor be deprived of life, liberty, or property without due process. Those are the unalienable rights that they even referred to in the Declaration: life, liberty, and the pursuit of happiness. Those rights were so important to the founders that they specifically set them down. But that does not mean that those are the only rights that we have. And then really quickly, the Eighth Amendment, excessive bail shall not be required, nor. Again, it is a specific prohibition against excessive fines, excessive bail, cruel and unusual punishment. But then this is the key to the Bill of Rights, the Ninth and the 10th Amendments. This was the compromise that people like Hamilton finally assented to over and above his concern of including the Bill of Rights, is that the enumeration in the Constitution, meaning, again, we're just specifically setting these rights down because we are so concerned and want to limit the federal government as an actor even further. So the enumeration of specific rights in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And then the 10th Amendment, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively and to the people. That was what Jefferson's quote was all about. He was saying, if you cannot see plainly in the Constitution the boundaries thus specially drawn on federal government's power, if we don't understand those boundaries and we don't rein in our federal government, they will have a boundless field of power that is not susceptible to any definition. The 10th Amendment is the least quoted amendment by any of our federal government, of course. Because, for example, like the Obergefell decision back in June of 2015, when the Supreme Court acted as a legislature, they tried to create law that is not even within the power of Congress, the federal legislature, to do. So not only did they usurp Congress's right, they didn't even take a right that was actually Congress's. Because Congress does not have any power within Article 1 to legislate in the area of domestic relations law. That is reserved to the states because it is not specifically given to the federal Congress. So that is why that decision was blatantly unconstitutional. They tried to create law, which they're not allowed to do. They tried, and then they also tried to go into and have jurisdiction over an area of law and of jurisdiction that they absolutely had no right to do in the Constitution. So we have to understand, again, the Bill of Rights in context and what Bill of Rights means. And I think that that actually, as a phrase, is sort of a misnomer. Because if we're saying it's a Bill of Rights, we're looking at it to specifically describe our rights. Rather than what we should call it is a bill of limited power for the federal government. That's really what it is. And we, as Americans and as citizens, need to understand that. So I promised we would go back and look at Article 5, because, of course, the situation now is, what can we as citizens possibly do about this? And if you're anything like me and you have taken the literal meaning of what I'm saying tonight, you are infuriated, and rightly so, because our federal government has absolutely usurped their authority within the legislative branch, the executive branch, and the judicial branch. There is no way that hardly any of the agencies that are given executive power actually can exist under Article 2. There is no way that the Department of Justice, in their current lawsuits that are going on with the states, none of that, they do not have the right to go back in and interpret law. All of these things are happening in our culture because of the progressive agenda and because we as American citizens don't understand our Constitution. And we are looking at the legal doctrines, which are the legal fiction, and we're trying to argue within that realm. We are not going to win if we try to argue equal protection clause as a doctrine. We have to go back in and say, what is the originalist view? And not only that, not only the education, we have to call our congressmen and our state governors and senators. We need to tell them, what are you going to do about this? And we have to say, as our representatives, we are not in a democracy, we are in a constitutional republic. And as my elected representative, what are you going to do to ensure that my rights are secured and protected? Because that's the only thing that you have power to do. What are you doing about it? The other thing that we can do is Article 5, which is the amendment section of the Constitution. There's a lot of confusion over what Article 5 means and what the scope of its authority is. The role and scope and purpose of the Constitution does remain intact, preserving and protecting rights. Article 5 simply provides the legal mechanism or the legal ability, the legitimate authority to continue to ensure that the Constitution fulfills its mandate. So what it allows is two ways to amend the text of the Constitution, which does not change our rights. It simply changes what the federal government's limited powers are, or it takes one of those powers, limits it further, like adding term limits to the Supreme Court justices, or it redistributes authority of the federal government, like taking away the power of nomination of a Supreme Court justice away from the executive. That's all that it can do, and that's all that it has the authority to do. So amending the Constitution simply redistributes or further limits certain powers among the federal branches. Our rights do not change one iota because they are given from God, and we can see that in the Declaration. We, the people, give limited powers to our government. We, the people, can redistribute them. How do we do that? Part of this is the Convention of States project. If you haven't heard of this, it's conventionofstates.com. And this is the project to utilize Article 5 of the Constitution and to actually call for a convention of the states. What Article 5 says is that the Constitution can be amended in one of two ways. Either by Congress in Washington, which they have the power to propose amendments to the Constitution any day that they are in session. They always have that power under Article 5. That's been done a number of times. Or if 2/3 of the state legislatures pass an application, and it has to be the same application through their state, if 2/3 pass that, a convention of states will be called for the purpose of proposing amendments to the Constitution. That's specifically in Article 5. It is not for the scope or authority to have a new constitutional convention, to change where our rights come from, to change the role and scope of the Constitution, to change the fact that it is the supreme law of the land. They can simply propose amendments. We've amended the Constitution a number of times. We have amendments that go beyond the Bill of Rights. Those have gone through other ratification processes, and we have never actually called a convention of states because it's very difficult. But it is possible when we, the people in our respective states, say we are tired of federal government usurpation. We are tired of Obama issuing edicts and acting like a tyrant. We are tired of the Supreme Court creating legal fiction and literally reading between the lines of the Constitution and grabbing all of the power that they want and that they think. We are tired of them being our sovereign and that we are at the whim of the majority of the Supreme Court. So this is the way that we can go back into the Constitution and we can say, what are procedural changes that would affect substantive ways that we can cure the usurpation in Washington? So the Convention of States project, and you can go to conventionofstates.com, is an organized effort that's actually in all 50 states, and we're up to a number of states now. I don't have the exact count, and anyone watching this later, that will, of course, change. But once we get to 2/3 of the states, Congress shall, by mandate of Article 5, call a convention with delegates from each of the states that will come for the purpose of proposing amendments. They are limited to the application You can see that on Convention of States website. And after that, assuming that they actually get to the specific language that they want to propose of an amendment, that amendment still has to be ratified by 3/4 of the states. And each of the states get one vote. So for those who are really concerned that an amendment is going to be passed that will be detrimental, we still have a ratification process for every other way that we've amended the Constitution since the original Bill of Rights. And this is a protection to ensure that 3/4, it's not a simple majority. That's actually quite large of a supermajority. That is a large number of state legislatures that will get together and actually either say yes or no. We may get all the way through a convention, propose amendments, and then none get ratified by 3/4 of the states, and then it's over. But we have the opportunity to go into Article 5, use that legal mechanism that the founders specifically provided. They realized that government corrupts. They realized that we had to have a separation of powers for a reason. They realized that our Constitution had to grant very specific, drawn boundaries around federal power. They realized that we might have to amend those powers at a later point in time. They specifically gave us this mechanism. This was their gift to us. And they specifically have said, and it was George Washington, and I don't have the exact quote in front of me, but he specifically said that Article 5 would be the way to amend the Constitution if a change is necessary through Article 5, but let it not be by usurpation. So we as citizens have the opportunity to take the gift from the Founding Fathers, to understand our Constitution, and to bring about practical, procedural changes to the power of the government. And so with that, I will conclude, and I will be open for questions. This is my contact information. My email address, my website, you can follow me on Facebook. If you have any questions that I'm not able to get to tonight, or you think about it later, you want more information about any of this, please feel free to email me. I've gotten a lot of questions and concerns about Convention of States, and some of those things I'm more than happy to answer them. And then also, this is my book that goes into a lot more detail about our Constitution and provides the legal reasoning that we can advocate for a biblical basis to constitutional interpretation. I've given you Originalism in the Bill of Rights, which is actually just one chapter in the book. If you go and you read the book, you will understand it goes more into the Declaration, the theories of law, and why we need to change the basis of how we advocate for biblical truth. Because if we are standing here as Christians and think that our only way to advocate is to say, well, I believe in the Bible, the secular progressives will say, well, I don't. And the argument's over. We need a legitimate legal basis. And we need to be able to say, truth is. Truth is, regardless of whether I believe it, you believe it, it doesn't matter. And our Declaration of Independence specifically recognized that. Specifically recognize that our rights come from God. And our Constitution was absolutely built upon that founding document's hierarchy, and we have to be able to advocate for that in our context and in our sphere of influence with our neighbors, our relatives, our state legislators and representatives, our state government, and also the federal government. So with that, I will conclude. And again, thank you all so much for being here. I really appreciated it.